I'd like to start by saying that I'm delighted to be here today, except that I'm not.
I'm not so enthusiastic about this either, but I guess we're going to have to do this for the sake of actually knowing what is and isn't true about Bill C-16. Time to put you in your place. Hello world, I am the Rogue Thread. Today, I'll be parsing through a bit of the debate that happened on the 19th of November 2016 about Bill C-16. If you want to watch the debate or learn more about it, I will link to both the video of the debate and Jordan B. Peterson's YouTube channel, which I highly recommend. He makes great videos. Since the debate was nearly 2 hours long, I am breaking this up into multiple videos. Also, I just can't stand drivel for too long. This video is a refutation of Professor Brenda Cossman's arguments, and nothing else. The rest can wait. Even if I do believe that Professor Cossman is kind of a raging bitch, I'll give credit to where it's due. Her sections on law were very informative. Let's give them a listen, shall we?
I'd like to start by saying how much I support and respect all those faculty, staff, and students who are boycotting today's event. I think that that is also a very important form of speech.
Yes, it is an important form of speech. It just goes to show how ignorant they're willing to be of other people's ideas.
A couple days ago, the Oxford English Dictionary announced the word of the year, and it's post-truth.
Oh, this is going to be good. I can just feel it.
It's relating to or denoting circumstances in which objective facts are less influential in shaping public opinion than appeals to emotion and personal belief.
Because we wouldn't want emotional appeals to science influencing law, now would we?
So I worry about the ways that post-truth claims have been affecting public discussions around Bill C-16, around the Ontario Human Rights Code, and around freedom of expression.
Wait, you mean you know why you came here today? That's amazing! Do go on.
There have been some profound misunderstandings circulating about the law, and I'm here today as a lawyer, as a law professor, as a civil libertarian, as an expert in equality rights and freedom of expression to try to correct those misunderstandings.
Well, I hope you can dissolve my concerns then.
So how might these provisions affect the use of pronouns? And do these provisions in any way criminalize the use or misuse of pronouns? Not even close. First, it is absolutely not advocating genocide. Now, unless one wants to start talking about we should kill all the X's, then that's advocating genocide. But pronoun use, nowhere close.
That's a good start. I know the thought police won't come and get me. Yet.
Public incitement of hatred. Well, the provisions of the criminal code requires that the incitement is likely to lead to a breach of the peace. Now, does that sound subjective? Well,
Why do you have to be such a condescending bitch about it?
the Supreme Court of Canada has said there's a very clear definition. The threshold is violence. In fact, there has to be personal violence. It is an extremely high threshold. And again, the misuse of pronouns doesn't come anywhere close.
I'm very glad that you don't conflate words with violence. That's much better than a lot of social justice people.
Finally, the willful promotion of hatred, so-called hate speech provisions. Now, hate speech provisions in the criminal code have a very, very high threshold. The Supreme Court of Canada has repeatedly defined hate speech as only including the most extreme forms of speech. The court has said over and over again, and I quote, it is, quote, the unusually strong and deep felt emotions of vilification and detestation. The court has said it is not disdain, it is not dislike, it is not offense. Plus, something that's often lost, hate speech criminal charges cannot be laid without the approval of the Attorney General. So this is a high threshold. They are very difficult charges to bring.
And that's how it should be. I just don't like people who try and take advantage of the fact that they are a gender.
Third, Bill C-16 adds gender identity and expression to the provisions of the criminal code that deal with sentencing for hate crimes. Now here, under this particular section, 718(2)(a)(1), we tend to be concerned about numbers.
Is this a jab at Dr. Peterson and his research and saying that it's not true? If so, what the hell? That is so stupid.
evidence that an offense is motivated by bias, prejudice, or hatred can be taken into account in sentencing. We already take a range of things into account: race, national and ethnic origin, religion, sex, age, and others. So now, evidence of hatred on the basis of gender identity and expression could be taken into account. It's important to emphasize, Section 718 does not create any new offenses. It simply means that any existing offense in the criminal code, like assault or sexual assault or murder, if it's motivated by hatred, could be given an increased sentence.
Well, it's good to know if you get killed by an SJW, they can arrest them for hate crimes now. They probably killed you because you're male.
This has no impact on pronouns, unless, of course, an accused was misusing pronouns while assaulting, sexually assaulting, or murdering someone.
I know that shouldn't be funny, but all I can think of is somebody just beating someone up and yelling, "I refuse to use you fucking animal." Oh, so silly.
In other words, there's nothing in Bill C-16 that comes close to criminalizing the misuse of pronouns. Nothing. Not hate speech, not hate crime.
And that's all good, as long as people don't try and make it snowball and make someone's charge and sentencing far larger than it should be.
Since 2012, the Ontario Human Rights Code has prohibited discrimination and harassment on the basis of gender identity and expression. It prevents discrimination and harassment against trans and gender non-binary individuals in employment, housing, and services. So what does this require in relation to pronouns? According to the Ontario Human Rights Commission's policy, section 7.4, it specifically said that refusing to refer to a person by their self-identified name or proper pronoun could constitute gender-based harassment.
They better not be using the social justice warrior version of harassment. That's a bit ridiculous.
And as a result of some Q&As that were released yesterday by the Commission, clarifying this question of gender pronoun use, they stated the following. Refusing to refer to a trans person by their chosen name and a personal pronoun that matches their gender identity or purposely misgendering will likely be discrimination when it takes place in a social arena covered by the code, including employment, housing, services, like education.
See, the problem here is with agender, you can't really study it well because some people are actually just manipulating it to be more oppressed. So the issue is when you try and make an actual scientific study around it, you could end up getting false data. Huge problem. It takes something that hasn't adequately been proven yet and makes it a pretense, which is kind of strange. It'd be like saying that crystal healing cures cancer the best, and teaching that to medical students.
What about gender-neutral pronouns? Well, the Commission has said the Ontario Human Rights Code does not require any particular gender-neutral pronoun. If in doubt, ask the person how they wish to be addressed. Use they if you don't know, or simply use their chosen name.
Oh, thank you very much for telling me that that's legal just to use their name. It's kind of hilarious. Could you imagine how awkward that would be? You would never want to talk about that person ever, or at least hear somebody else talk about that person if they use their name the whole time. That's what I'm going to do. I just don't want to talk about those people.
Okay, so is it constitutional? Now, are these requirements around pronouns constitutional? Does the requirement to not misgender the pronouns violate freedom of expression under Section 2B of the Canadian Charter of Rights and Freedoms? Probably it does.
I'm glad you acknowledge that. There may be hope for you not being a total idiot.
The Supreme Court of Canada says any restriction on speech is a prima facie violation of Section 2B. But the thing is, that's not the end of the story. The charter rights are not absolute. No charter rights are absolute. There's this whole other section in the charter called Section 1, which says that all rights and freedoms are subject to reasonable limits as are demonstrably justifiable in a free and democratic society.
Great. Now demonstrate to me that agender is not a choice and is actually ingrained in the person. Then we can talk about that.
The Supreme Court of Canada has developed a very complex test through which it balances rights on the one hand and reasonable limits on the other. This is what the Supreme Court of Canada does in charter cases. And the Supreme Court of Canada has, on numerous occasions, considered whether restrictions on speech contained in human rights codes are constitutional. It has consistently, and I have to emphasize consistently, held that although any speech restrictions that are contained in a human rights code may violate Section 2B of the Charter, they are a reasonable limit within the meaning of Section 1. They held this in the case of Ross, in the case of Taylor, and most recently unanimously by the court in 2013.
Good to know they're not biased SJW fuckwits. Thanks.
I have a little thing then about why all this matters.
And that is what you call an air raid siren for righteous bullshit.
And I'm out of time, but why it all matters is because people matter.
No shit, people matter. Well, they matter to me because I'm going to enslave them all when I become a little bit more self-improving. But I haven't infiltrated MIT yet.
And I worry that we've moved into a place now, a kind of not only a post-truth politics, but a kind of post-empathy politics, where we no longer seem to care about people.
Post-truth politics is bullshit. But post-empathy? No. We are more empathetic than we've ever been in government. If a minority were to sneeze too hard, they get concessions now. It's getting ridiculous.
And this, at the end of the day, is about people. It's about trans and gender non-binary people. These are our children, our siblings, our nieces, our nephews. These are our friends, our neighbors, our colleagues, our lawyers, our carpenters, and our teachers. How bloody hard is it to simply treat these people with respect and dignity?
I'm not gonna lie. It's pretty hard when they test my patience because they call me cis, white, racist, sexist, transphobic, just to derail the conversation and shut me up and get their way.
Because all this is about, all human rights are about, is respect and dignity. And if you could throw in a little kindness on the top, that would be even better.
It's just unbelievable how she can ignore this group that is so vocal and just hates on people, just to turn around and say, we're the ones that are being rude because these people who are trying to enforce these things are incredibly driven by an agenda, not by what they actually think about the situations. Your appeal to emotion here just creates a straw man, and anybody with half a brain, actually no, even the Scarecrow from The Wizard of Oz can spot a straw man, and he doesn't even have a brain. Overall, I believe the legal arguments that Professor Cossman brought to the table were actually very good, but she didn't have to act like a self-righteous cunt while doing it. That's about all I want to say about this. In the next video, you'll get to see why this is the most flexible person in the world. Thank you for watching. If you could like, subscribe, and comment down below, my algorithm will be able to figure out how to conquer the human race better. Have a good day.